Aside, meanwhile, Algon in the States says it's going to go with the order of the industrial court, not the Federal High Court's judgment. That means, in as much as Justice Akombi says the elections have been dissolved, as far as we are concerned, the elections have is non-existent. We reject such an order.
Are you bound
what do we see?
Are you bound to respect an illegal order?
Definitely.
You're not.
Okay, so 2 wrongs make it right. Do 2 wrongs make it right?
First, there's a court, there's an order.
Do 2 wrongs make it right?
2 wrongs don't make it right.
Okay.
No, but there's an order.
Mr. Oka is still on the line. Let's bring Mr. Oka, thank you for staying on the line. I'm sure you've been following the conversation, the back and forth of the conversation. We brought in the 90-day notice thing, but Mr. Peters, I think that shouldn't be the focus now. The focus should remain on the fact that this is an illegality. Justice Akombi had adjourned Synodine, and now he's just coming up, waiting for the Supreme Court, the Court of Appeal, to give its verdict on this matter. And now he's coming back to give a judgment, assume jurisdiction and give him on an issue, according to him, that is technically not before him. How should this go forward?
Thank you very much. Sometimes I sympathize with Dakuku's argument because I'm not sure he's sufficiently versed in law to be able to profile the kind of opinion he's doing, and that's the reason why he's mixing up a lot of things. But let me take these issues one after the other. He said it is not obligatory on his part and on the part of members of his team to obey an illegal order in his judgment. But it is right to agree that where the laws made by the State House of Assembly are in conflict with the provisions of the Electoral Act and the Constitution made by the National Assembly. In his view, it is better that it should be allowed to stay, it should be obeyed, just because no court of law has set it aside.
He did not really say that, though. Did he?
That's what I heard him say. What he said is that until the state law is set aside, it seems to be the proper law.
What he said is, if anybody has an issue with that law, the person should go and challenge it in court. And that law has not been challenged in court, and elections have been conducted based on that law for many years. That's what he said.
My reply to that is very simple. You cannot make a law which you have no power to make. The State Assembly cannot make a law which it has no power to make. And as far as we are concerned, the fact that nobody has gone to court to challenge that law does not make it proper law, because there are superior laws governing the relationship in the state and the federal government vis-a-vis conduct of local government elections. That's that. Coming to the fact that, in his view, the Federal High Court should not have dissolved the local government council, because in his view as well, there is a subsisting court order from the Yenegua Industrial Court. I'd like to ask, did the court in Yenegua restrain the Federal High Court in Port Harcourt from adjudicating over a matter that was properly before it, before the matter was taken to the appellate court? There was no such order restraining the Federal High Court. The order from Yenegua, the Industrial Court in Yenegua, is that the governor of Rivers State should be restrained, and a few other parties should be restrained from dissolving the councils. And clearly, the governor of Rivers State did not dissolve the councils. The court in Port Harcourt, the Federal High Court in Port Harcourt, properly seized of the matter, dissolved the councils. Now, as to the way forward, which is where I'm a lot more interested in, the way forward is not to abuse the judges. It is not to abuse the judiciary and humiliate judicial officers when they do their work. When it pleases you today, the judiciary is good. The judiciary stands for the common man. When it does not please you, you begin to throw all manner of tantrums and abuses and invectives on the judiciary. I do not think that that is the best way to go. There must be an end to this kind of rascality. Now, if a party is dissatisfied with the decision of a court, our laws are clear. Please proceed to the next level, the appellate level. And do not take laws into your hands.
Mr. Oka, if I may come in here, how do you marry these two? According to what Mr. Petersai has said, the industrial court has given an order, which is a court of competent jurisdiction, to maintain status quo, so to speak. That's what you said. Do not interfere in the local government administrations. Now, Justice Akombi, according to him, has gotten up to adjudicate on a case that he had adjourned Sinodine, waiting for the Court of Appeal to give its verdict on the same matter. So, according to him, Justice Akombi should have waited until the Court of Appeal gave its ruling. So now that Justice Akombi has given this ruling, and there is an industrial court ruling, they are choosing to stand by the industrial court ruling. Are you saying they should have gone to appeal Justice Akombi's ruling, which is supposed not to come until after the Court of Appeal ruling?
Let me address you on the issue of appeal. There was no appeal as at the time the Federal High Court in Port Harcourt gave its judgment. There was no pending appeal. To the best of my knowledge, the appeal had been withdrawn. The appeal had been withdrawn, so there was no appeal. Justice Akombi was right in hearing the matter and giving his ruling because there was no appeal. And I challenge whoever says there was a pending appeal when Justice Akombi delivered his judgment to please show you the records of the court. Secondly, I am saying that the National Industrial Court sitting in Yenegoa, I do not want to go into whether it has the jurisdiction or not to decide a matter which is not purely an industrial matter. I do not want to go into that. I also would not want to ridicule a court law because I am a lawyer. The point I am making is that there was no order from the National Industrial Court sitting in Yenegoa directed against a court of coordinate jurisdiction, being the Federal High Court sitting in Port Harcourt, not to hear a matter properly before it. Two, there was also no order. There was an order from the National Industrial Court directing the governor of Rivers State not to dissolve the local government councils in Rivers State. And as we speak today, the Federal High Court, not being subject to any restraining order, sat properly on a matter before it for which no appeal was pending and gave a judgment. Governor of Rivers State, Chief Yeso, having not dissolved the council and being the governor of Rivers State, took advantage of the vacuum created by the dissolution of the councils by the Federal High Court and appointed members of the caretaker, chairman and members of the caretaker committees and swore them in properly. So I do not know where this conflict in the mind of some persons will be coming from. But whichever way it is, a court order remains a court order. If you are dissatisfied with it, please take advantage of the appellate jurisdiction. Go there and ventilate your grievance. Don't begin to overheat the system. Don't begin to abuse the judges.
All right, Mr. Oka. Let me just cut you. Let me cut you in here now. With the claims and counterclaims from both sides of the divide, as we speak, 23 of the local government areas, before the dissolution of the councils by Justice Akombi, which is under a lot of scrutiny right now, and there's a lot of controversy surrounding it. What is the next step for the Rivers State government? A caretaker committee has been sworn in by the governor of the state, Mr. Chibuike, and at the same time, Algon says it's not going to budge. So what is going to happen? How is the state going to run? And what is the next move for the government at this point?
The Algon you're referring to, if I want to put the record straight, I hope you're not referring to the former Algon. The present Algon we are talking about.
I am talking about the 23 elected local government chairmen, those who were duly elected, considering the fact that Justice Akombi ruled Sinodine.
there are no more 23 elected